Very good morning. I'm Hamida from SDM Law College, Law School. Today I'm going to discuss about the topic relating to tort and essential elements of tort. Actually, the tort which came to India through England, and that the term tort derived from the Latin term tortum, which means crooked or unlawful act. Means in generally tort in the sense what? It is a civil wrong. It is not a codified law. How we see in Indian Penal Code 1860 and other laws like Indian Contract Act 1872. So it's not a codified, it's not having any year or not amended in any particular year. Only on the basis of a principle, it's relating to principle is good equity, justice and good conscience. On this basis only the courts have given the judgment. And not only that, the means in India, many of the when giving of the judgment, the courts are going to follow the various landmark cases already given in England and some other countries. So now today we'll discuss about the essentials of tort. Here the tort it's having three essential elements. That is, first one, it is the wrongful act. Second one, it is the legal injury. Third, it is the legal remedy. First, it is a wrongful act. Wrongful act in the sense what? Whatever the act committed by a person which is against to the law, which is omission of the law, means that whatever the law who gives some duties and rights to the all the people, if they violated, if they infringe to those rights, then it is considered as a wrong only. Means we are going to against to the law, means omission of the law happened. Now second one, it is the legal injury. So in law of tort only we will discuss about the legal injury, it is not the common injury. What is the difference between the legal injury or the common injury? Legal injury, it is nothing but the law who gives rights to all the human beings. Like when we see about the constitutional rights, again when we discuss about the human rights. So like many of the examples, various articles in the whether in the it is constitution or human rights, right to dignity, right to live, right to equality, right to get education or exploitation or employment. Many of the rights we have. If someone trying to violate our legal rights, it's our liability to approach to the court and we will get the remedy. Until unless, without any legal injury, if we approach to the court, then the court will not take any action. Example in the legal injuries, two of the famous Latin terms are there. It is relating to the legal injury, that is damnum sine injuria and injuria sine damnum. First Latin term, it is damnum sine injuria. Damnum in the sense it is nothing but damages, sine it is nothing but it is without, injuria in the sense it is injury. What injury? It is a legal injury, means the damage caused without any legal injury. So if damage caused without any injury, can court accept those cases? No, the court cannot accept these kind of cases, because of for that we have the other kind of acts are there. But in the law of torts, if without any legal injury, we cannot approach to the court. Example of various landmark cases are there. It is relating to the Gloucester Grammar School. It's damnum sine injuria. Two related landmark cases are many are there, but in that also two are very landmark cases are there. The first one is the Gloucester Grammar School, and the second one is the Richard versus Stevenson case. So first case we just briefly will discuss about the Gloucester Grammar School. So the Gloucester Grammar School, it is one of the famous school. So against to that particular school, one of the rival schools started, and for this school got much loss, and he went to the court for that monetary loss. Then the court not accepted. The court said for any pecuniary loss without any legal injury, they cannot accept in the court. Now going to the second Latin term, it is the injuria sine damno. Injuria sine damno in the sense legal injury happened without the loss, without the damage. Legal injury happened but without any damage happened, in the sense without any loss happened. Like example, with here also two important landmark cases are there. That is, first one, it is the Ashbai versus White case, and the second one is the Bhim Singh versus Jammu and Kashmir case. So we know that legal injury, just now I discussed about the legal rights. If someone who trying to violate our legal rights, we have a right to approach to the court. Same like that in the Ashbai versus White case also, violation of giving the oath means here the infringement of violation of legal right happened. Means here in that Ashbai versus case, the commissioner who not accepted the vote of that particular party. So giving vote is our legal right. If someone not accepted that, not given such a right to the person, then it's violated. So we have a right to approach to the court, though the court accepted and also have given the remedy. Same like that in the Jammu and Kashmir case, Bhim Singh versus Jammu and Kashmir case also. In that case, the Bhim Singh they detained to that person to not to enter into the assembly. He was the MLA, so he detained to not to enter into the assembly meeting. Then that person who approached to the court and filed to the people. Then the court said this one is also comes under the injuria sine damno, because of entering into the assembly, discussion of the meeting and attending the meeting. It is a legal right of every person, so it's a violation of legal right happened. Then the person have a legal right to approach to the court, and this case accepted in the court. For that, he got the remedy, that is the 50,000 rupees of compensation. He received it. So this is the second essential element in that two Latin terminologies covered. It is relating to the damnum sine injuria and injuria sine damnum. The third, it is essential element, it is the legal remedy. Legal remedy in the sense it is connecting to the above two essential elements. That is about two essential elements is the first one, wrongful act, and the second one what we have discussed, that is the legal injury. So when we get the legal injury, automatically we will get the legal remedy, and that one, it is also legal remedy. It is the unliquidated damages, we can get it from the court. Now we want to know about what is liquidated damages and unliquidated damages. First we have to understand about the damage means what, damages means what. Damage is nothing but it is the injury. Damages, it is nothing but it is the compensation. So compensation when we can get, when it is a wrongful act happened and when it is a legal injury happened. If we both get, then only we will get the legal remedy. In the law of tort, the court will give the compensation unliquidated damages. Unliquidated in the sense it is uncertain amount, means the court will award the uncertain amount, not the certain amount. So when we discuss about the example of the certain damages and the uncertain damages, certain damages, when we see in the contract, law of the contract, it is happened in between, the breach of contract happened in between two of the parties, then the court will award the particular compensation. Suppose if party lost 50,000 rupees, then that party approached to the court for that compensation of the 50,000 rupees only. Means here the court only award the 50,000 rupees, whatever he mentioned in the suit. Where in the breach of contract I am saying. But now coming to the breach of contract, when coming to the law of tort, it is unliquidated damages. Unliquidated damages, it is not certain amount. It is completely depends upon to the court. Sometimes the court will give more than the injury, and sometimes it is less than the injury. Might be sometimes the court will award the future injury or future remedy also. So it is completely depends upon to the court. That's why the remedy is called the unliquidated damages. So this is about the essential elements, brief introduction. We have the separate topic, it is relating to the remedy. We have the separate topic, it is relating to the legal injury also be there. So in the next class we will discuss about these two essential elements.